Welcome back to the channel. I did say I would do some further podcasts on this channel because, hey, YouTube introduced podcasts, so why not, right? So I decided to set up a consumer podcast, and in this particular one, I'm going to start to talk about some real-life examples we have of clients having difficulties with their cases and how we deal with those and how we approach those. So in this video, in this podcast, we're talking about how to deal with a situation where you've bought a car and there's something gone wrong with it. Now, whether it's a new car or a second-hand car, much of the law is the same. There are some discrete differences, but overall, it's still consumer law. So overall, we would deal with it as barristers, as lawyers, we would deal with it as a consumer law case. So dealing with those in turn, if you buy a brand new vehicle, then aside from a very subtle distinction, which makes vehicles different from every other product, which is the same regardless whether it's a new vehicle or a second-hand vehicle. The distinction really between a brand new car and a second-hand car is that with a brand new car, obviously you would expect zero blemishes, zero scratches, zero defects, zero wear and tear, zero anything that should not be on a brand new vehicle. Whereas with a second-hand vehicle, clearly you should expect some degree of wear and tear, some degree of blemishes and scratches and marks, and subtle performance issues and things like that. Not to the degree that it makes it unfit for purpose and not to the degree that it makes it unsatisfactory quality. But that is, again, something I'm going to come back to in just a moment. So the main difference other than those that I've just mentioned between vehicles and any other product as a consumer purchase is by the time you get to court, ordinarily, let's say you've bought a camera and the camera for whatever reason just doesn't work and you've complained and you eventually end up in court to sue to get your money back. The trader, if you've exercised your right to reject, which again I'll come back to in a moment, if you've exercised that right to reject, the trader cannot make any deductions from the value that you've spent to purchase this thing. That is a distinction with vehicles. Now, if it is a motor vehicle which is defined broadly as anything you'd expect a motor vehicle to be, then the trader can make some deduction for the use of that vehicle during the time that you've got it. So if you've used the vehicle for however long it might be, 2, 3, 4 weeks, 2, 3, 4 months, you would expect the trader to take some deduction off the value of any refund because of your use of that vehicle. This would have a stronger rebuttal in the sense that if it's a brand new vehicle, and I'll give you an example, quite a stark example. One example was a brand new vehicle on the higher end, about £90,000 worth. It was an electric vehicle. Won't name the manufacturer or dealer because that's not necessarily fair. But for this example, at least, but for this example, there was a serious defect with this vehicle, and not just this vehicle, but this fleet of vehicles, or at least a batch of this fleet of vehicles. And so much so that the dealer manufacturer insisted that all of these vehicles are recalled. And so they called each of the consumers, customers that had bought these vehicles, one of whom was one of my clients, to say that they should abandon this vehicle if they are out driving, or just not drive it if they're at home. The reason being, these vehicles were liable to spontaneously burst into flames, and therefore that would be dangerous. And so they recommended that these consumers don't drive the vehicle. They arrange for the dealer to come and collect it, bring it back, and await repairs. Now, in this one particular case, my client had only had this vehicle for a matter of days before getting this warning from the dealer, and therefore quite clearly, quite obviously, quite rightly and justly said, well, forget it then. I don't want you to repair this brand new vehicle. I would prefer you just have it back, give me my money back, or swap it for a different vehicle. This went back and forth for several months before finally coming to me. And we're probably 6 or 8 months down the line by then. And eventually I had to say to this dealership, there's no alternative. You won't sort this out. We're going to sue you. Now, it's about £90,000, as I said. Still a consumer case. People think of consumer law. They think of it's £50 here or there, or a couple of £100 at best. But a consumer case includes those that are for a brand new vehicle, whether it's £5,000 or £150,000. It's still consumer law. There's subtle differences with the finance, but we won't get into that in this podcast. But otherwise, the law is pretty much the same. I say pretty much the same because there is a distinction which comes about through case law, which does have some effect upon the consumer law. And that is a case that decided, and if I find it, I will link it in the description to this podcast, but a case that decided that is more of a comment by the judge, but which is successfully used readily in consumer cases to this day. I've used this successfully as an argument in my cases before now. That being that the more you spend on something, the higher the degree of quality you should expect. So it is as simple as that. The more expensive something is, the better quality you should expect, and therefore the less sort of wiggle room that they should have for any kind of defect. And quite clearly, if you're buying a brand new vehicle, that sets it apart somewhat from a 10-year-old second-hand vehicle, clearly, for much less money. And so in that situation, it was very clear-cut. The dealer should have taken back and either fully refunded this vehicle or swapped it for something else. Now, this comes about through the consumer rights in the Consumer Rights Act 2015. And so as a very short overview here, which I will develop in further podcasts on what we do about it and how do we progress these matters, the short summary version of it is this. You have a short-term right to reject in the Consumer Rights Act. Incidentally, if you buy something online, you've got a 14-day window within which it replaced the old distance selling regulations. But the 14 days you can cancel the contract regardless. If you've bought it online or a distance sale or off-premises sale, so you're not on the business premises, let's say they come to your house or you're over the phone or you're online or whatever. But aside from that 14-day window, which you may have heard of, there is a standard 30-day short-term right to reject. The importance is in the wording here. It is a right to reject. So it is a statutory right which cannot be taken away. You may have heard the phrase, these terms or whatever are in addition to your statutory rights. Now, a statutory right is something that cannot be taken away. It's a statutory right to reject within 30 days if it does not conform to the contract. And the contract being not just what you've agreed with the trader, but also any terms that are implied into that contract by the Consumer Rights Act, which are very broad. It's got to be satisfactory quality, it's got to be fit for purpose, it's got to be as described, and there's a few things that come into play here as well, many of which are not really relevant to vehicles, but they do apply to all sorts of other products. But with regard to being of satisfactory quality and fit for purpose, if it's brand new, that comes back to the issue where it should be free from defects and minor blemishes and things like that. But generally, it should also be fit for purpose. So it should be, regardless of whether it's brand new or whether it's a second-hand vehicle, it should be roadworthy. It should be safe. It should not be sold to you in a condition which requires further work before it goes out on the road, unless, and there is a caveat, but I'll come back to that in a minute. So it should be fit for purpose in that it should be roadworthy, should be able to go out on the road without any work doing to it, and you should be able to just drive away knowing that this vehicle is okay, it's safe, and you can drive it away. That is the purpose of it. The purpose is to drive it away. Now, fit for particular purpose also includes things such as, for example, if you ordered a vehicle up and your comment to the trader was, this must be fit for towing a caravan. And they say, yes, of course, sir or madam, this is perfectly capable of towing a caravan. Now, if you then take the car away and then you try to pull the caravan and it burns the engine out because it just wasn't capable of pulling the caravan, there's some arguments as to the size of a caravan, whether it's a reasonable size that could reasonably be within the contemplation of the parties as to what you expected to pull and tow as a caravan. But let's assume that that is the case and it is a caravan, but the vehicle was not capable of doing so. Then it's not fit for purpose because it's not fit for the purpose that you've made known to the trader. And this is regardless of whether or not this particular vehicle is ordinarily designed to pull the caravan or a trailer or whatever it might be. If you've made that purpose known to the trader, it should be fit for that purpose. And if it's not fit for that purpose, then it is not fit for purpose according to the Consumer Rights Act. And so within that 30 days, if you go on your holiday, you try to pull the caravan, it burns the engine out, it doesn't work, you would be within your rights then to go back to the trade and say, this wasn't fit for purpose. You sold me something on the basis that I was going to pull the caravan with it. It clearly failed, it burnt out. So I would like my money back. I'm rejecting this vehicle. Now, that's when we come to the rejection. Now, when you reject something under the Consumer Rights Act, it's by whatever you say or do to indicate that you're rejecting the vehicle. It could be as simple as a phone call. It could be walking in to say, this is rubbish, I'm rejecting it. Or it could be driving it back or having it towed back there or whatever it might be. Taking it back and getting it back to the trader, or even if you don't take it back to the trader, if you walk in person and say, this thing is now in my garage at home, it's blown up, but I'm rejecting it because it's rubbish, then you've rejected it validly according to the law in the Consumer Rights Act. Now, there's two things that are triggered there. One is you have a right and the duty is upon the trader to refund you without undue delay. So they must refund you without delay if you've rejected it within that period, that 30-day period, and you have a duty to make this available for them to collect, which clearly if you've taken it back to the dealer, you've made it available by bringing it back. But either way, you've made it available, you've got a duty to make it available. They then have an option to offer you a repair or a refund, but if they offer you a repair and you say, okay, I'll give you one shot at repairing it or making it good again, then that 30 days, the initial 30 days, is put on hold. This is what a lot of traders do not understand. And we've had to go to court before now on the basis that the trader just didn't agree, but they were wrong. Even sometimes their lawyers are wrong because they don't agree. But the 30-day period, the initial 30-day to reject, is put on hold if you wait for the repair to be done. And then they get one shot at repairing it. And so if 3 months later, there's two things here. First of all, 3 months later, if they give it back to you and it's still not right, it still doesn't work, it's still not good enough, still doesn't tow the caravan, whatever the case might be, you can then say, right, well, you've had one shot. The 30 days was put on hold for the waiting period for you to try to repair it. So I am now exercising my right to reject it within the first 30 days. Traders will disagree with you. Their lawyers will disagree with you. They'll try to bully you to tell you, well, some of them will at least, to say, no, we are beyond the 30 days. You cannot reject it anymore. That is not true because within the Consumer Rights Act, there is a provision that says the waiting period for you to wait for them to repair puts on hold that initial 30 days. And I can probably find that within here. I didn't have this open to hand, but I can search it up now. If I look up waiting period, we are section 22, which is the time limit for the short-term right to reject under subsection 6. And it states as follows: if the consumer requests or agrees to a repair or replacement of goods, the period mentioned in subsection 3 or 4, which is that short-term right, duration of 30 days to reject, stops running for the length of the waiting period. This is a statutory provision. It cannot be overridden. It cannot be taken away, cannot be nullified. You cannot contract out of it. This is a statutory period within which, if you agree to a repair or a replacement, the period that you're waiting for such repair or replacement puts on hold that initial 30-day duration for the right to reject. So, as I said, many traders and many of their lawyers get this wrong, and either, I won't say deliberately, because I won't say that lawyers are deliberately getting this wrong, but certainly overlooking at best this principle that this is put on hold. So you are free, of course, to look this law up yourself or take advice on it and quote this section and say, My 30 days has not expired because I came to you. Let's say you went to them on day 10. They said, we'll repair it. They took 2 months to try to repair it. They failed to repair it successfully. You go back and say, forget it. I now want my money back. I am now exercising my right to reject. That is called a final right to reject after you've accepted one attempt at repair. And so once they've tried and failed with the repair or even replacing with something else that is still not good enough, you can then go back and exercise your right to reject, and in which case they should give you a full refund. As I said, the slight difference with vehicles as against other products is that the trader can, in most cases, make a small deduction for your use of the vehicle during that time, and a court is likely to find the same. A court, depending on the time frames, let's say you took it back 5 days after, a court may well say, well, I'm not making any deduction. You took it back very promptly. I've seen this before in court. You took it back very promptly. There was no real delay on the consumer's part. It's not right that the trader make any deduction at all for the use of the vehicle. Therefore, the court orders the trader to make a full refund. So that is the basis upon which you would reject a vehicle if it's not of satisfactory quality, not fit for purpose, and various other things. Of course, with any case like this, it's always a matter of degrees. It's a matter of how wrong is the vehicle. If you're talking about a bit of wear and tear on the seats and the steering wheel for a vehicle that is 10 years old, don't waste your time, because that is not what the Act intends to protect against. On the other hand, as in one case that I had just recently, the car was driven away, and within the first 3 days, it was blowing white smoke out of the back of the vehicle. That is quite clearly not fit for purpose, because it clearly needed some work doing to it. And in fact, my recommendation in those cases is get it straight to a garage to do a diagnostic on it. Yes, it costs you some money, but then you've got a sheet of paper that says there's something wrong with this vehicle. Even if, and I contend, even if it doesn't say this is what is causing it, if they just acknowledge there is a defect with the vehicle. We can't find it yet, but there is a defect because it shouldn't be blowing white smoke out of the back, or whatever the defect is. In that situation, you've got a sheet of paper that says this vehicle is defective. In my view, not that this is legal advice to your own particular circumstances, because every case is different, but in my view, in the generic sense, with a case like that, you go to court on that basis. You have a sheet of paper telling you that the vehicle is not fit for purpose because it should not be blowing white smoke out of the back. Therefore, a court is likely to say you've validly rejected it under the Consumer Rights Act. The dealer has a duty to refund you, and if they haven't done so, then they have to do so. And in those cases, you will be ordinarily able to claim interest, and depending on the value of the claim, if it's not more than £10,000, it will be a small claim, so you cannot then claim back. Ordinarily, you cannot claim back your legal fees unless the other side has been behaving unreasonably. But if it's more than £10,000, then fees implications, as in costs implications, do come into play. So you can then claim back your legal fees. But you are also at risk to costs, adverse costs from the other side if you lose. But if you have a strong case, and I would suggest if you are in one of these fairly clear-cut cases like this, where there is clearly a defect with the vehicle, you've clearly rejected it, you've got a report to say that it's faulty, you've taken it back, then in almost every case like that, they should be refunding you. There are some arguments, of course, depending on, have you caused the damage? I mean, if you had a tiny little vehicle that was clearly not capable of pulling, a huge load, and you tried and it blew the engine up, that's obviously not what this Act is intended for. Whereas if you've made it known to the trader that that's what you want to do, you want to pull a caravan with it, then clearly it's not fit for the purpose that you've made known to the trader. So there it is, a very, brief 20-minute overview on dealing with car problems, whether it's new or secondhand, and interplay with the Consumer Rights Act. But they are still dealt with as consumer goods, assuming that you've bought it as a consumer. Business is entirely separate, although there is a mirror provision for business-to-business sales. There are still provisions for satisfactory quality and fit for purpose, but we're talking about the traditional, the old-fashioned Sale of Goods and Services Act that apply to businesses and still applies to businesses. But I hope you found that overview useful. I hope you find this slightly more relaxed discussions type podcast. Please do remember you can subscribe to my channel still, even though this is a podcast. And please like the video, even though it's a podcast. But hopefully this is useful to those of you that are on the move, on the drive, and you want to listen to podcasts and get some useful insight on a journey. I'll try to keep them to about 20 minutes in length. Obviously, I can talk on these issues, but feel free to let me know what you would like topics on for these podcasts. And I thank you so much for watching, and please do join me next time.